All right, thank everyone for your attendance today, and we're going to hopefully allow everybody an opportunity to speak. We've got a number of individuals representing various interest groups and themselves who want to speak on the bill, and we're going to do our best to accommodate everyone speaking. I would like to ask, I know we've got some who are representing the same group, and where you can, please not be too repetitious in the points you're making. I want to tell you that we're taking up the House version of the Juvenile Justice Reform Act, and in all great deference to our good Senator Bill Hamrick, who passed out his bill a week or so ago. Our main interest is to be sure that we have a bill that continues from one house to the other. I don't know what may happen with Senator Hamrick's bill at this point. No one does, but we hope and expect that it will arrive on the House side by crossover day, but should there be some hiccup in that, I didn't want to have a chance that the bill dies because of that. So we're proceeding with the House version, and that bill we hopefully will have passed out of committee early next week as a bill to be considered by the House, and I believe we hopefully will receive a good support. The chair wants to exercise his privilege to speak on the bill on certain issues about it because there's been a lot of interest and concern dealing with both the prosecutor's responsibility under the bill and also the injured defense and providing defense for children under the bill. And these are two very important aspects of state policy that we're placing in the bill. We think it's required already, of course, by law. We think that being a juvenile facing possible detention really is not any different from an adult facing detention. And in doing so, there is a need to have a proper person representing the state as a prosecutor on those crimes that rise to that level. And there's also certainly a need that the child have the appropriate defense and representation through counsel on that issue before a juvenile court. So we're not going into waters that we shouldn't be venturing into. We're under a mandate, as I see it, not only by federal law, but by the standards of this state and policy of this state. We're doing it by putting it in writing. And I know there's a lot of interest and concern regarding where is the money going to come from or how much money even it may be. And there is not any empirical information or data, frankly, that we can draw on at this point in time that tells us that whatever may be done in the fulfillment of that obligation will take a certain sum of money. Philosophically speaking, personally, I've said this several times, I'll say it for the record, the state through the General Assembly and our state constitution faces an obligation to be sure we provide from a court standpoint that there is a superior court, and in that court there are judges who are compensated by the state, and there are prosecuting attorneys compensated by the state, and there are now defense attorneys, where necessary, also provided by the state. That is what we exercise as our responsibility, and hopefully we have fulfilled it and will continue doing so. Below that level, you have other courts. We refer to those as the inferior courts, which are the state courts, the juvenile courts, the probate courts, and of course your local city and county courts. These are all courts and personnel and judgeships that are really funded not by the state but by local government. And that is the way the practice and I think the Constitution of our state has established those needs. It gives the local jurisdictions the option, and certainly the exercise of that option for the establishment of a juvenile court is part of it. The state does not mandate juvenile courts. It sets up the procedures for them. It sets up the responsibility for them. But the option of setting it up is, frankly, as I see it, a exercise of local government and the superior courts working with that local government. With all that said, where are we going? My intention, and with the support of my committee, is to recognize and continue what we currently have in the law as to the responsibilities for prosecution and for a defense attorney being appointed, in this case, by a local juvenile court judge where necessary. I do not intend to have what will be the current language that we have dealing with the responsibility of the Indigent Defense Council's requirements, which is statutory, in providing defense at this point to a juvenile court. That was also, I think, a position taken by Senator Hamrick's committee in the Senate. They removed that provision. It doesn't mean the responsibility is removed. We are facing several major policy changes in the state under this bill. It is an important change. It is important issues and policies that we're trying to place in effect. We have a lot of, I think, deficiencies in the way that the state has mandated the way juvenile courts operate in the treatment of juvenile individuals, especially those being considered for detention by the state. So it doesn't mean we're changing what we're going to do in the future. We are not able to say today in the enactment of this legislation precisely what the cost may be. We know there will be additional cost, and we're not going to avoid that cost. But we have a period of time, because the enactment date of the legislation does not become effective until July the 1st, 2013. Therefore, we have another year and approximately 4 months to address these final issues about fiscal needs and appropriation of monies to fulfill what we have as an obligation at the state level and what may be expected at the local level in the area of providing either prosecutors and defense counsel for the courts. To that end, as I stated earlier, my expectation is, with the support of my committee, we're going to recognize that there is still the existing responsibilities. It is not going to say how that responsibility will be provided at this moment. If people can trust in us and the legislature and working with the governor, and I know we have the support of the governor on these policy matters, we intend to address that fiscal responsibility between now and the next session of the General Assembly, our regular session next January, and begin finding the proper appropriations to meet our responsibility and begin fulfilling it for a future. With that said, I hope that the parties who are here representing prosecuting attorneys as well as Indigent Defense will bear with us on that expectation. I know you say, well, that's a lot to put in as a hope, but I tell you, it's a necessary hope, and it's not going to be something we're going to ignore. We have a bill that is 245 pages in length. We're also going to have, I know of 7 amendments that will be offered at the conclusion of the debate and the testimony today from various parties. I would ask any member of the committee, if you wish to have an amendment presented which has not yet been brought to my attention, to please have that drafted out in proper form, identifying the section as well as the lines within the bill that you wish to present that amendment to. Do we have any comments that, since I've exercised my privilege, any comments from any members of the committee at this time? If not, we will proceed with hearing testimony from various parties. I know that we have Kirsten Widener with the Barton Center, who is also representing Just Georgia. And I'll ask Ms. Widener to come forward, please, and identify yourself and who you are representing. I'd like to also ask you, if you could, to give the committee information regarding the numerous interest groups and parties who participated over the term of this project. Can you bring your mic around? Thank you, ma'am.
Thank you so much, Mr. Chairman and members of the committee. My name is Kirsten Widener, and I am the Director of Policy and Advocacy at the Barton Child Law and Policy Center, which is a part of Emory University's law school. We are also one of the 3 lead partners in a coalition called Just Georgia, which consists of not just the Barton Center, but also Voices for Georgia's Children and the Georgia Appleseed Foundation for Law and Justice. Together, we have worked to take a product that was produced by the Young Lawyers Division of the State Bar of Georgia, which was a proposed model juvenile code for Georgia, and incorporate into that feedback from stakeholders from all over the state. We have worked with, we have an active working group of stakeholders that has a mailing list of over 100 individual attorneys, advocates, and youth representatives. And we've worked with organizations such as the Prosecuting Attorneys Council, the Georgia Association of Criminal Defense Lawyers, Southern Center for Human Rights, the different child advocacy offices that represent children in abuse and neglect cases, particularly the Fulton Office of the Child Attorney and the DeKalb Child Advocacy Center. We've worked very closely with Georgia CASA and a lot of their affiliate CASA programs. We have worked with this, I just blanked on what they're called, the Child Advocacy Centers of Georgia that do forensic interviewing of abused and neglected children. We have worked with the Georgia Commission on Alternative Dispute Resolution, as well as the Council of Juvenile Court Judges, the Council of Superior Court Judges, the various different state agencies, including Department of Juvenile Justice, Department of Behavioral Health and Developmental Disabilities, and Department of Human Services in particular, and worked very closely with all of those teams and many others who I'm sure that I have neglected to mention. But again, it's been a robust and well-represented community of people, and then of course most importantly we've had involvement from the youth themselves. Children who have been through the foster care and delinquency systems have experienced firsthand the types of systems that we're talking about today, and some of them are here to share some of their experiences with you today. Mr. Chairman, you had asked me to highlight for the committee some of the changes that are in the substitute version of the bill from the version that we reviewed with this committee during special session. For those of you who were present, we did a full presentation on the full content of the bill back in August. Would you like?
In fact, we had 2 days of hearing in this committee during the special session, and I think we covered a great deal about the background, the policy issues, and changes we're making. So you might go through highlighting where we are today.
Great. Some of the testimony that you heard during the summer sessions included testimony from juvenile court judges who raised a couple of lingering concerns that had not been addressed. 2 of those concerns were related to the system of providing representation for children in abuse and neglect cases. In particular, the previous version of the bill required that each child be appointed an attorney, but had the appointment of a guardian ad litem as optional, and required that if there was a guardian ad litem in addition to an attorney, that those 2 representatives for the child be separate people. That's a little bit different from what we do under current law. Under current law, the child is entitled to an attorney, and the child is also entitled to a guardian ad litem, but it's okay for that to be the same person. We have reverted to current law with regard to those provisions to the extent that a child is required to have an attorney and required to have a guardian ad litem, and we are expressly permitting the same person to serve both of those roles unless or until there's a conflict between those roles. So we recently had a Supreme Court advisory ethics opinion come down that was approval of a state bar ethics opinion that said that if a child's direction to their representative is different from what the representative thinks is in the child's best interest, then as an attorney, you can't represent both the best interest and the child as an attorney. And so this bill takes that ethics opinion and basically incorporates it into the law. We also, in clarifying those child representation provisions, made sure that we stressed the importance of the role of Georgia CASA and CASA programs in general in providing volunteers to advocate on behalf of children. Whether or not the child has an attorney who's also serving as guardian ad litem, the CASA could still play a very valuable role for that child if available and appropriate. And so we wanted to make sure it was clear that it was still okay to appoint a CASA separately, even if you have an attorney guardian ad litem for the child. Another issue that the judges had raised when they came before you back in August was around continuances. And specifically, we had a requirement that requests for continuances be made in writing and be made at least 48 hours prior to the hearing. That's very different from current practice, where most motions for continuances are made orally and they can be made up until the last minute. And sometimes the reason for a need for a continuance comes up at the last minute. We had a very easy time identifying an area for compromise here. Nobody felt strongly about retaining that written motion requirement, so we've just stripped that out of the bill. Continuances can continue to be done like they've always been done in terms of oral motions and up to the last minute, so long as the motion is only granted if there's good cause. We've also had some feedback from the Department of Juvenile Justice regarding one provision in the Children in Need of Services article, which is Article 6. That article would have required that children who commit status offenses, and those are children who have done something that wouldn't be a crime if they were an adult, but is an offense because of their age as a child, things like running away from home, truancy, skipping school, curfew violations, those types of things. That those children be kept separate in facilities from children who have committed more serious offenses. And we used the term sight and sound separation, which is a term from federal law that means that they can't see or hear each other. Federal law requires sight and sound separation between children and adults, but it doesn't require it between different categories of children. This was some place where our bill went further than federal law requires. DJJ did not feel like they had the ability in their facilities to separate children without doing new construction, and that would be cost prohibitive. They are doing their best to separate children as a matter of policy based on risk level and to provide protection for children in that way. And as a result, we removed the provision requiring sight and sound separation in order to ensure that the department was able to support the bill. And we believe that we have addressed all of the Department of Juvenile Justice's concerns. The Department of Behavioral Health and Developmental Disabilities had asked for a number of changes. A couple that I want to highlight for you that are included in the bill. There are two types of evaluations that the Department of Behavioral Health is routinely asked to do by different juvenile courts that were not part of the Georgia Code. And the department thought it would be helpful to have those types of evaluations defined, have really clear procedures for courts to be able to order those evaluations and get additional information about the child. Those two evaluations are called behavioral health evaluation is the first one. That is sometimes in our courts today called a disposition evaluation. It's intended to give a judge information about a child in order to help them plan an appropriate disposition for that child. So just additional information about the child's mental health status, their treatment needs, things that a judge might need to craft an appropriate dispositional order. And so we added a definition for that and a process for ordering those evaluations. Additionally, we added a transfer evaluation. So if a judge is contemplating transferring a child to Superior Court for one of those offenses where that transfer is optional, then that transfer would be something that they could get an evaluation of the child to see is the child's mental health status such that an adult adjudication would be appropriate for this child. So those two types of evaluations and mechanisms for ordering them are included in the bill. Additionally, the Department of Behavioral Health asked for some significant cleanup on our competency provisions. As you know, our bill greatly expands the competency provisions of current law to make it very clear what we need to do when a child who is accused of something that could result in a loss of liberty. So if they could potentially be put into a juvenile detention facility, we need to make sure from a constitutional standpoint that they are competent to assist in their representation. We have expanded those provisions greatly from current law, and we wanted to tweak those and make sure that they were going to work appropriately for both the courts and for the department in terms of handling those cases, and we believe we've come out at a much better place and have been able to incorporate some great suggestions from the Department of Behavioral Health. And I know, Representative Welch, you had just done the adult competency provisions with the department, and I think they learned a lot through that process that we were able to incorporate. We all did. Additionally, we had some changes to federal law, and one in particular required a change to the bill. There was a reauthorization of the Federal Child Abuse Prevention and Treatment Act in 2008, and that in 2010, and that reauthorization required us to have a couple of additional circumstances under which we do not require courts to try and reunify families. So generally, if we have an abuse and neglect case, we try and provide services to the family to make it safe for that child to return home. We have some exceptions to that under current Georgia law, which are things like if the parent has killed another child of the parent, a sibling of the child, or has caused severe bodily harm to this child. The federal law added a couple of additional categories that we had to incorporate in. Those are if the parent has been convicted of a sex offense against this child or a sibling, then we are not required to do reunification. The court still can if they feel like it's appropriate, but we're not required. The other is if the parent is required to register as a sex offender, and that sex offense is one that makes reunification not in the best interest of the child, then we would not require the courts to go through reunification for those children. And so those provisions to incorporate federal law were also made in the substitute that you have before you. Finally, there were two changes that were made by Chairman Hamrick as he was proceeding through with his committee. The first was an issue that we had not been able to establish agreement between the stakeholders on, which was about admission by an unrepresented child at arraignment. We had previously banned any admission at arraignment by a child, whether or not they were represented, with the idea that you want to take the time to gather information about the case and see if it's appropriate to make an admission or not. We had compromised with all the stakeholders on allowing a child to admit if they were represented and had received counsel about that. The judges felt that because we are requiring a child to consult with an attorney before waiving counsel, that it would be appropriate to go ahead and if they've had that consultation with an attorney, to go ahead and let the child waive. The defenders wanted to preserve that. Chairman Hamrick made the policy call there and took out the provision preventing admission at arraignment. So a child under the version of the substitute that's before you, and I know there's an amendment prepared for this issue, but under the version of the substitute that's before you, the child would be able to admit at arraignment regardless of whether the child was represented at arraignment. Finally, as the chairman referenced in his opening remarks, Chairman Hamrick added a change to Title 17 of the Georgia Code, which is where our indigent defense, Georgia Public Defender Standards Council provisions are. And that change would remove from the Georgia Public Defender Standards Council the responsibility for having a circuit public defender for juvenile court. That change did say that the counties could contract with the Georgia Public Defender Standards Council, and that if they chose not to contract with GPDSC, that they would have to be bound by whatever standards the agency had. So that was the scope of that change. That was it's in section 3.1 of the bill towards the back, and that was an addition made by Chairman Hamrick. That is the largest policy changes between the substitute that you have before you and the version we discussed back in August. However, there were numerous other minor technical changes and tweaks. I don't want to imply that those are the only changes, but those are the substantive ones that represent a different policy than we previously had represented in the bill.
Others dealt with mostly issues of clarification, being sure that we had it properly stated if there was confusion or uncertainty about it. You will have some questions, I believe. First, Representative Lindsay.
Yes. I appreciate your hard work on this, man, and I think that you took a very good idea and y'all turned it into an excellent one, and I commend you. When we're talking about the conflict between the lawyer, if the lawyer is also acting as a guardian ad litem, is there an age differential? I mean, you know, a 6-year-old, you know, tells the guardian ad litem he wants to go live with Papa. I mean, and you know, it's clear that he ought to be living with Mama, or vice versa. I mean, and I understand if it's a 13, 14, 15-year-old child, but it seems to me that the guardian ad litem ought to have a whole lot more discretion as the child's lawyer as well for a 6-year-old as opposed to.
And frankly, in practice, that's how it works, because as a lawyer, we have responsibility not just to go to the court and say what our client wants, but we also have a responsibility to counsel our client. And so if I have a 6-year-old who's asking to do something that is clearly dangerous to the child, then my counseling conversation is very strong, and it is about the fact that there's very little likelihood that the judge is going to allow you to do that, and you need to allow me to present the judge with some options that the judge might actually consider. And so in practice, it does work as if there's
and I've been there. I've done the guardian work, but I just want to make sure I understand if that 6-year-old still stubbornly insists on doing X, but when Y is the best route, obviously. I mean, are we going to have to get 2 different lawyers at that point?
If after counseling the child has a strong opinion that does not seem to be made from a place of incapacitation, right? There are standards in our professional code for representing a child with diminished capacity. And if the child has diminished capacity, then there is some room under our Georgia Rules of Professional Conduct for substituted judgment for that incapacitated child. But if the child has full capacity and has taken a strong position on their legal representation, then they are, under the code today and as is represented here, entitled to a lawyer who will represent that position. You would have a separate guardian ad litem then appointed, perhaps, but it wouldn't necessarily have to be a lawyer guardian ad litem. In many cases, that's going to be a CASA volunteer, and it may be a CASA volunteer who's already associated with the case, who's already working with that child.
Thank you, Ms. Widener. Anyone else have questions of Ms. Widener? I want to personally thank you for the great work you've done for the last, 3-4 years in working on this bill. Through
5, not that I'm counting.
Pardon me. 5 years, and I know you've dedicated so much of your time and energies to it. It's just, I think we all commend you for what a great effort you put into it, and we thank you.
Thank you so much. Before I step down, I was asked by the Georgia Sheriff's Association. They were not able to be present. They've got a hearing on another bill, but Sheriff Scott Berry gave me his card so you could know that I'm actually speaking for him, and he signed it. And he wanted me to share with you all the Georgia Sheriff's Association support for HB 641. And so I have his signed business card with that statement for y'all here if you want to see it.
You got fingerprints with
Thank you.
Verification. Well, thank you. I believe our next group of speakers will be some of our fine juvenile court judges in our state. We have Judge Michael Key and Judge Peggy Walker. If you would please come up and join us. Judge Walker has been a long time dear friend of mine, and Judge Key, I don't know if we've ever met personally, but I know you've also, I think we have, but I know you've also been president of the National Council of Juvenile Court Judges, correct? Is that, and just recently completed that term. So we're very thankful for both of you here and like to hear from you regarding the bill. Ladies first.
Hi, thank you. I can tell you that I have been involved in this process since 2003 when we began to realize that it was time to update the code. And these 5 years of meeting have been very open, very inclusive, very transparent. We've had an opportunity to be heard on every single issue, and there have been compromises made. This is a huge move forward in terms of policy and in terms of procedure. The things that I want to share with you come from the work of the National Council of Family and Juvenile Court Judges, and I've been asked to speak in regard to national standards, national practices, and how this moves us forward in that direction. One of the things that we know that's important is using our resources wisely. And one of the ways to do that is when you have one family, one judge, you have the opportunity to know what needs to be done. You and your community know what the resources are, and you know how to best utilize them. So that consistency of having one person to hear all of the cases, whether we're involved in deprivation or whether we're involved in delinquency or status offenses or issues of competency, it makes sense for one person to deal with that family. So the resource guidelines for the dependency cases, which is what is the term used at the national level for the deprivation cases, this has been adopted in and formalized as part of this code revision, and we think that that's a significant change and an important change. A second thing that I would share with you is the fact that throughout the process there have to be written findings. It was very common at one time for there to be a practice in Georgia where you simply found a child deprived, but you didn't state the reasons. That makes it very hard to design a case plan or a roadmap to go home. You have to have specificity, and you have to do case plans that are effective and appropriate if you're going to do your job right to get children home. And then the third thing that I would point out to you in terms of the dependency side of the work is the fact that we have a new procedure now to expedite things for children under the age of 7. We know that when we move children we're doing harm. We also know that the younger the child is, the greater the harm is. It's very important to get children home in a timely manner, and it's really our job to make sure that we are doing this well. And having a differentiated approach for younger children is a good thing for us to do, and I want to point out to you that that's consistent with what the recommendations are for those best practices. In the delinquency arena, there are two things that I will point out to you before I yield to Judge Key. Having a prosecuting attorney to decide what is filed in delinquency and to determine which cases are appropriate to prosecute makes sense. It is not appropriate to use court staff to do that. It's certainly not appropriate to use state staff through the Department of Juvenile Justice to do that. Also having the ability to have appeals of cases where cases have been transferred to the Superior Court as an interlocutory procedure before the case goes to trial also makes sense. It is important to have representation for children, particularly if you're going to have a situation where the child has a loss of liberty, but it's equally important to understand that if you're looking at being separated from your family, if you're looking at possibility of having to be in another school, being out of your community, it's very important to have effective and well-qualified and well-trained legal representation. And we appreciate the commitment that the legislature has shown to looking at the well-being of our children. When we do a good job with our children in meeting their needs and in addressing issues of well-being, then they have the ability to be productive citizens. And that really is the goal of the juvenile court, is to have healthy children who are well cared for in the state. Judge Key and I have come from Rome, and we'll be returning to Rome, but we want to be available for you for whatever length of time you need us during this hearing to answer any questions that you have. This time I'll yield the floor to Judge Key.
Judge Key. Judge Key is with the Troup County Juvenile Court. I didn't mention that. Pardon me?
Yes, he is.
Yes, he is.
That's my legislator.
And I know Judge Walker is with Douglas County
Yes, and
Juvenile Court.
Representative Bruce is my legislator.
There you go. And y'all have a conference going on right now that you took your time away from, of all the juvenile court judges up in Rome. Is that correct?
It's the judges that are involved in the Court Improvement Initiative. It's
Very
not all
good.
the judges.
Well, I'm glad you did that, and we're grateful to hear from you.
Well, thank you. Mr. Chairman, members of the committee, and I was going to acknowledge my representative, Randy Nix. I want to first commend you for the courage and persistence in seeing this bill through. I've been on the bench for 23 years, and I practiced in the court for 10 years before that. And it's about time. A lot has changed during that time period. People have changed, practices have changed, challenges have changed. And the law, even though we've had a patchwork changes from time to time, it's really not kept up. This is a tremendous framework to serve the children and families in Georgia. It's a great framework. I bring two perspectives. One Peggy mentioned. And by the way, Judge Walker is now Secretary of the National Council, and if she acts right, then she will be president in about 3 years.
Didn't know that.
So we're honored to have that. So number one, I bring the national perspective of some hands-on experience with resource guidelines. In fact, I currently serve on the committee of the National Council that is reviewing the guidelines and enhancing them. The practice has changed since 1995 when the guidelines were initially enacted, and 2001 when the adoption guidelines were enacted. So we're reviewing current practice in law and enhancing those guidelines. More importantly, though, is I bring the perspective of a single juvenile court judge from the state of Georgia. And most of the things that are contained in this bill we have in Troup County, Georgia, in our court and in our community that we've built. The expedited hearings, the frequent reviews by the courts, front-end loading of services, most of the things in here we have. And I can tell you from the ground in Georgia, the red clay, that these things work and they make a difference in the lives of the children and families that we serve. I particularly think that the increased, expedited reviews and the increased judicial oversight is important. A lot of state law is driven by federal law in this area of child welfare. Every time Congress passes a bill, a significant child welfare bill, most recently Fostering Connections, they give the juvenile court judges additional judicial oversight. The fact that you recognize that we need to review these cases, conduct the periodic reviews earlier and more frequently is a testament to the importance of these reviews, and our judges are prepared to accept that challenge. I also want to talk very briefly about the trauma that children serve, and both in terms of deprived children when they're taken from their homes by state action, but also when we speak to the issue of legal representation of children. Children have a different sense of time, number one. But when we look at the trauma that a child can suffer, you can't really equate providing a lawyer to someone if they face up to 6 months incarceration as an adult, or a child if that child faces incarceration at all. And I do believe that all of our children need to have legal representation with delinquent and unruly cases. And applying these principles in this bill, the same ones we do in Troup County, we've been able to safely reduce the number of children in foster care in Troup County from 223 to less than 50. We have our delinquent caseloads down. Our average is 60 to 70, and our community is safe. We ensure public safety even as we do those things. So these things work. If you have any specific questions,
that's great to hear what you're doing. Any questions from members of the committee? I'll ask a question, and that is, I'd like to get your comments, either one or both of you, with regards to the need of having a proper risk assessment, as I call it, of a child prior to the consideration of the court of either that unruly child, the child who's committed a criminal conduct, as to what may be done or should be done as far as incarceration, detention.
I'd like to speak to that issue. The detention assessment instrument gives us a way to objectively make decisions about whether to detain children or not to detain children. But we do need to have some flexibility because there are times when we need to be able to do judicial overrides. One of the things that is important is that we address the fact that we have overrepresentation of minority children, children who live in poverty, and one of the ways of neutralizing the detention decisions is using that detention assessment instrument. But at the same time, we actually have to be able to look at the situation, and let me give you an example. 2 years ago, I was on my way to a graduation at Alexander High School and received a call asking to override a detention decision. This child scored out at 12 and above. She had a charge that essentially, I don't remember the specifics of, I assume at that time it was aggravated assault because the young man had not died. But what happened is there was a 15-year-old girl, her 17-year-old boyfriend. They had a gun. They took the clip out of the gun, and then she pointed it at him, fired it. She thought it was empty. He thought it was empty. There was a bullet in it. And, of course, she was in shock, and she was in very bad physical and mental condition. She would have had to go to detention had there not been the ability to override. It was something that was very dangerous, obviously, but I needed to have the discretion to say that was not the appropriate thing to do under those circumstances. Law enforcement recognized that and contacted me and asked me to do a judicial override. So I think that the instrument is valuable, but we always need to have the ability to use judicial discretion because there are circumstances where detention really is not warranted.
Thank you. And you have any comment on that, Judge Key?
No, sir.
The reason I asked the question, I have a provision in an amendment. I want to read it to you, dealing with the obtaining of a behavioral health evaluation, we call it. That's risk assessment, same words. says the court shall order and give consideration to the results of a child's behavioral health evaluation before ordering any final disposition confining such child in a secure detention facility. Does that mean what you see is about just the fact you give consideration to it, you're not required to be bound by it?
Correct.
Okay. Very good. Thank you.
Mr. Chairman, just
Yes,
say one
sir.
thing about that. I'm not sure in context where that piece fits. If we're talking about detention at intake, one
No,
difficult.
this is, I'm sorry, not that.
Okay.
It's talking, there's another portion that deals with that, but this is talking about where you're going to commit that child to the state
Okay.
for long-term detention.
I agree with that.
Great. We're on the same page.
Thank you, sir.
We have also a question, I believe, again, of Mr. Representative Lindsay.
I've just, when we had the hearings last summer, y'all expressed concerns with how we were going to be doing the attorney thing, the attorney issue. And I appreciate the work that's been done on it, and I think that it sounds good to me. But particularly Judge Walker, you had raised some concerns about how it was originally. Are you comfortable with what we've done here now?
I am. I think that the compromise reach is reasonable.
Okay. I just want to make sure.
Great. We're grateful for
Thank
you
you.
being here, and we'll understand if you'd like to leave to go back to your meeting.
Just a little while.
Next, I have Gordon and Jonathan. Maybe I got Giovan. I'm sorry, Marcus and Jonathan. That's from the Georgia Empowerment. Ah, yes, very good. Please come in, identify yourselves, and who you represent.
Good afternoon, Mr. Chairman, thank you, and members of the committee. My name is Giovan Bazan. I'm 21 years old. I was in the foster care system for the first 12 years of my life, and I was in the juvenile justice system for the preceding 8 years of my life. And I'm currently a youth advocate. I testify on various pieces of legislation in the best interest of the youth within the foster care and the juvenile justice system, as well as various other issues. And today I have with me another advocate from Empowerment, and he'll introduce himself, and I'll explain a little bit about who we are at Empowerment.
All right. You can pull that up closer to the mic. Good.
Hello, Chairman. My name is Marcus Lee. I'm 20 years old. I'm a youth advocate that actually came through the Department of Juvenile Justice, and I represent Empowerment as an advocate. And wow, I never thought I'd be here.
Okay.
To be honest, I never thought I would be here before the board to actually speak on my own experiences.
Well, let me ask this both of you before you go to your presentation. Did either or both of you spend time in detention with the Department of Juvenile Justice?
Yes, sir.
Yes,
3 years to
Georgia.
be exact.
Tell me how much time each of you had.
Collectively, I spent over 3.5 years in juvenile detention confinement,
3 years in
All right.
and the longest period was 1 year and a month for me
Okay.
at one stretch.
Go ahead then. Thank you.
Thank you. So ultimately, we're a statewide advocacy network called Georgia Youth Empowerment, an initiative of the Multi-Agency Alliance for Children, which is a collaborative of several different community organizations and psychiatric treatment facility and foster care agencies that work in the best interest of children and youth across the state of Georgia. Empowerment is, like I said, a statewide advocacy network of former and current foster youth and advocates and allies who are dedicated to revising and reforming the foster care system in their best interest. Out of Empowerment, we created the Just Georgia, or became partners, members of the coalition of the Just Georgia Coalition, to represent that youth perspective here at the legislation at the House and the Senate side, so that ultimately the laws that are being implemented that will ultimately affect the trajectory of the youth's lives is appropriately developed based off their experiences, based off our experiences, based off what we've been through, identifying what didn't work for us, what did work for us, and what needs to be improved ultimately in our best interests. So I'd like to jump right in. We had lined up 2 other advocates that were going to present with us today. Unfortunately, they won't be able to be, so I have the distinct pleasure of representing their cases as well, their personal experiences as well. So I'm going to jump right into Article 3, dependency, and I'm just going to cover a couple of the more important changes. I mean, obviously, they're all of significant importance, but the ones that have relevance to the advocates ourselves and the ones who couldn't be here today. Article 3 dependency, one of the amendments says that it emphasizes that siblings who are taken into state's care should be kept together whenever possible. This is absolutely imperative. I'm sure that everyone can imagine the travesty, the damage that could do to someone, to a child, to a teenager, someone who's trying to identify themselves, and for them to not even be able to affiliate themselves with a family. I mean, it's just despicable to say the least. And you can only imagine the long-term effects of that can have, when a child growing up, not even being able to be with their own family. Secondly, clarifies that defects must show they have made reasonable efforts to preserve or reunite the family or to find permanent home for the child at every hearing, and provides factors for the court to consider in determining whether reasonable efforts have been made. Once again, this is critically imperative to keep the family united in the best interest of the children. It's not necessary to separate the child at every case, and in the instances that it is, sometimes it's appropriate for them to be reunited. And as it stands now, that doesn't happen in all cases. Also requires the court to make detailed findings to support placement and case plan decisions known as dispositions. In making these findings, the court is to consider the child's attachment to significant people and his or her school, home, and community. With the emphasis on their school, home, and community, we understand, or we are familiar with the old idiom, it takes a village to raise a child. And it's those significant support systems, it's those significant people who have made a phenomenal impact in our lives that help us to determine who we're going to be in life. It's what defines us. It's what helps us to feel comfortable with ourselves and ultimately be successful. And when you take those significant connections that a foster child may have, whether they may not be their immediate family, but it could be a coach, a mentor, a school teacher, it could be their caseworker, it could be a neighbor. But when you take that away from that child, it's another feeling of abandonment, it's another feeling of neglect, and it does more damage than it does positive. So it's very important to keep those together. Moving on to Article 5, independent living services. I could talk for hours about the how very imperative and very important this is to the well-being of children and youth. As it stands now, there's not enough being done as it relates to independent living services for foster children and youth in the juvenile justice system, specifically here with youth in foster care as this relates. While in foster care, you grow up with a lack of stability, a lack of certainty as to what your future is going to hold. And it's that instability, that lack of security, that makes it difficult for one to grow up with a sense of normalcy. And so, plus coupled with the fact that there are certain extracurricular activities that youth in foster care can't be involved in, they can't participate in, they can't go on overnight field trips, they can't, stay after school to be part of the chess club or ROTC. It's all these things that take away from the normalcy of a child, that ultimately the long-term effects are going to be awkward social skills, lack of normal childhood development, and these may seem almost irrelevant at the time, but long term, I mean, the effects are extremely detrimental. One of the changes is 18 youth who have turned 18 must enjoy a quality of life appropriate to their age and make the transition to self-sufficient adulthood. Goes on to say age-appropriate opportunities such as sports and extracurricular activities, as well as interaction with mentors. Like I said, is critically important for them to be able to develop that strong support system, as well as that normalcy that most people are given the opportunity to have. It also makes changes to provide setting education and career goals, receive guidance about the steps necessary to achieve these goals, and when possible be offered internships and other work-related opportunities. When I was in foster care, I grew up in a foster home that was extremely abusive, mentally, physically, and sexually. The foster parents the only consistency that was with them was to tell me how I didn't deserve to be with them, I didn't deserve to eat the food that was on the table, and ultimately I wouldn't amount to anything in life. By the time I was 18, I would either be dead or in jail. A morbid forecast for anybody, but especially for someone who had a troubled childhood. So it's this revision that says that we want to encourage our youth. We want to encourage them with setting goals for their future. I didn't know what I wanted to do with my future, and had it not been for certain circumstances that I've been put in to lead me to this place, I could have been anywhere. Most likely I would have been like many of the youth in the juvenile justice and the foster care system who don't have those supportive mentors and people in place. They're either in jail or they face recidivism, homelessness, poverty. Right here it says aftercare services for young adults 18 to 23, including mentoring, tutoring, and mental health services. According to a study, and I don't want to say specifically because I can't remember verbatim, but the average adult isn't self-sufficient until the age of 27. So for us to cut off services at the age of 18 or even the age of 21, I mean, that's just ludicrous, because you're someone who's in the foster care system, you know, and has lacks the self-sufficiency necessary to fully stabilize themselves. I mean, that's the whole point of them being in the foster care system, to foster them with a sense of care. Moving on to Article 7, delinquency. This, of course, applies to my experiences in the juvenile justice system. And it right here, it says it requires the court to appoint a separate guardian ad litem for the child when his or her parent fails to come to court or is unwilling and able to protect the child's best interest. In my certain circumstance, the reason I was in the Department of Juvenile Justice was because while I was in foster care, I was running away from the abusive home as the only means for me to get away from the abuse. And at that point, it was considered a status offense. The only reason it was an offense was because of my status as a juvenile. So at that point, I began getting on juvenile probation. I began getting sent to detention centers for the simple fact that I was running away. Every time I went to court, I didn't have the opportunity to stand up for myself and to vocalize my opinion, nor did I have the developmental maturity to truly grasp what was transpiring and articulate that. So at that point, it was my parents' responsibility to my foster parents' responsibility to advocate on my best interest. Well, for them, they obviously didn't have my best interest at heart, and so their advocacy was what they wanted to see happen, which was ultimately, you know, lock him up. You know, he doesn't deserve to be home. We don't want him at home. He's a danger to us, etc. So it would have been having that separate guardian ad litem advocating for my best interest that would have changed the trajectory of my life. And the final two states that a child whose case is transferred to adult court should remain in juvenile court rather than adult detention facilities until the child turns 17. When I went into the juvenile detention center, I was in the juvenile detention center for running away, which was a status offense. The youth who I was also detained with had serious criminal charges like sexual offenses and battery, and there were even some youth who were in there for murder. So when you think about someone you think about a youth who's being exposed to all these negative behaviors, they begin to manifest these behaviors, and then when they get out, they tend to, it seeps out into their actions. And so, you know, you can only imagine how for lack of a better term, how moldable a child is, how influenceable a child is. And so, which is why it's critically important for them to stay separated up until the age of 17. And finally, it adds additional factors for a judge to consider in determining whether to order restrictive custody for a child who has committed designated felony, a delinquency classification requiring that a child be committed to Department of Juvenile Justice custody for a substantial period of time. Specifically, the court must consider the child's maturity, culpability, and educational dependency background. And that plays into the discretion of the court, which is critically imperative as well. At the same time, you know, in my circumstance, I committed a designated felony. I had a pocket knife at school with no intention to hurt anybody. I just happened to have it in my pocket. I served a year and a month, and I served a month extra because I didn't have anywhere to go. And so I had to serve a month extra, which is ludicrous. For a crime as simple as that, it was just, I mean, it's preposterous that a child would have to serve that much time when, I mean, clearly the lesson was learned, you know, when I was arrested. But I had to serve a whole year, and had this been allowed, you know, at the discretion of the judge, had they realized that, you know, this isn't necessary crime or this isn't necessary punishment for the crime, then once again, I would have had several different career opportunities available to me. So that is my spiel, and real briefly.
Marcus, you'd like to add from your perspective?
No, sir.
You all right?
I'm fine.
I think I covered all of my points and some of his.
Well, I think it's a credit to both of you that with what you've described as your background, Giovanni, what you had to go through in the systems, as we call it in Georgia, that you so well and fully overcome what could be a real major disaster in your life, and either it was a disaster, you've overcome it. And I think it's great for both of you to do what you're doing now as advocates. So we're grateful for you being here today.
We look forward to the passage of this bill.
And I think you're fully supportive of the bill, correct?
Absolutely.
Yes,
all right. Thank you so much.
Thank you so much.
For your time.
Glad to have you. Next we have is Ms. Linda Pace. this pace I've known for 4 years we want to describe.
Yes, I believe, Chairman, we met when I was doing environmental law with the DeKalb County Water and Sewer Department
That's right.
as a grants attorney for a year after I got out of law school.
That's right. And I think I was county attorney at the time.
You were indeed, and in that capacity, we had to work together on that grant. Ladies and gentlemen, thank you for listening to me this afternoon. I am here. I'm one of the stakeholders that has been involved in the process, the evolution of this proposed statute, this proposed revision, major revision of the Juvenile Court Proceedings Code. The first one, major revision since 1974. So this has been a tremendous work. It has been a great deal of my consciousness for the past few years, and actually I got involved in this through Senator Hambrick before the Younger Lawyers section came up with their wonderful model act from which the current bill is drawn. And we actually spent a year of fairly intense work on trying to redraft and to start this project. It was then apparent that the Younger Lawyers section was the appropriate group to be doing that, and they hired an incredible group of people to do that. And Kirsten has worked very hard on shepherding the bill along through numerous stakeholders meetings. I have been a juvenile public defender for 32 years. The juvenile public defenders have been under the state umbrella since 2005. So during many of those early years, it was strictly county by county. Every county did their own thing. Nobody, when I started 32 years ago, really wanted to be a juvenile public defender. The private bar wasn't out there wanting juvenile cases, and it was not glamorous. It did not pay well. It was considered, it was not looked upon as something that lawyers should strive to be. It, however, became dear to my heart and became extremely important to me. And so up until 2005, being involved in a very high-quality juvenile public defender office for DeKalb County was what I was interested in. And I must say that DeKalb County, through their chief public defenders, have always been, since they took over in '92, from the juvenile court, which originally was the public defender hire and fire. When the county took over, the county public defender's office in '92, they elevated the concept of juvenile defense to what it has become today, which is a specialty that is extremely important. These are some of the most important cases that you can possibly imagine. Now, Larry Snyder, who retired, he was involved in that initial push to make juvenile defense important, valued, and high quality in DeKalb County. He also was involved in 2005, leading up to 2005, when the indigent defense, juvenile defense became a state function instead of a county-to-county function, except in those counties that opted out. Since that time, my perspective has broadened, and it has happened that it has broadened to want quality representation for the entire state. And that's what I think the purpose of putting juvenile defense, which is no less important than any other criminal defense type position. I think that having contact with other juvenile public defenders around the state has enabled us to work together on an even larger group. We always collaborated within our office, and we always pushed each other to work really hard to do the best possible job we could for the kids. That is also true on a statewide level. There became a network of juvenile public defenders. And there was some mention made, Judge Walker also indicated that resources are known best to those who work in the community where the resources occur. Well, that's true of juvenile defense. And in large part, the money for juvenile defense and the training of juvenile defense and the expertise to improve the quality of juvenile defense comes not from the state, not from the counties, but from a national organization, the National Juvenile Defender Center, and from a regional organization, the Southern Juvenile Defender Center. The trainings, our CLE, our seminars, training experts, consultation with experts are all paid for by these organizations, which are funded through foundations. They're funded through the ABA. I recently received an email from the National Juvenile Defender Center indicating that they had received a 2012 MacArthur Award for Creative and Effective Institutions. This is an award that is given to 15 organizations in 6 countries. It is given to diverse groups in human rights, microfinancing, housing conservation, and education that have the common characteristic of developing innovative and effective solutions to vexing problems. This, since past 15, 16 years, these organizations have worked really hard to improve a specialty. They're not, a real estate attorney in Albany does not want to do juvenile defense,
Right.
should not do juvenile defense. It is essential that this be.
Yeah, it takes special training, experience working with youth. I agree.
It does.
Let me interrupt for a moment. I don't mean to stop your presentation, but as all of you see, members are getting up, walking out. They're not leaving forever. They're going because we all have bills. They're also in other committees. We all meet at the same time. It seems like I have a bill myself that's very important that I need to go present to a committee, and I'm going to excuse myself for as short as time as I can and turn the meeting over to the Vice Chairman, in this case, Mr. Jacobs, to handle during my absence, please.
Okay.
Ms. Pace, right?
Yes.
All right.
Yes. In addition to
Go ahead.
causing attorneys possibly around the state who are neither prepared nor anxious to do juvenile representation, throwing them into that arena, there are a lot of collateral cost to the type of basically turning the clock back to the point where counties are responsible, solely responsible. You lose uniformity. You require the county governments to incur organizational cost, administrative cost. I know that the people who have to the judges have to find attorneys who are not normally before them, but in conflict cases, things of that nature. Takes a lot of time on the phone. There's substantial cost associated with that. There are the potential if this doesn't work, and just, I mean, when you're working along one tract and you're doing your very best to improve and develop a situation, and then all of a sudden that scatters and everyone is on their own again, it just seems to me that is, I assure you, will cost everyone a lot more. I'm surprised the Department of Juvenile Justice has not come in to speak to you yet, because if judges and their secretaries have to find attorneys to represent children that are detained, which they do by law, because those children are constitutionally entitled to representation, those children may have to sit in the detention center until the judges can find somebody to represent them, which will increase the pretty extravagant costs that the Department of Juvenile Justice pays per day per child, not to mention the agony and the unnecessary detention. And as Giovanni said, sometimes children get locked up because their parents don't want to take responsibility for them. And those children are, of course, in desperate need of someone who can speak up on their behalf, someone the judge will listen to. Giovanni probably could have said what he needed to say when he was 15, but it's not likely that a judge would have listened to him explain his situation and act on that. So you're going to have increased DJJ costs from longer terms of detention, from getting longer terms to trial. There are expert witness costs the counties are going to have to bear. These are, again, constitutionally mandated. There are the right to a fair trial requires that in some cases that money be spent on the defense of a child. I don't know what the answer is, and so what I would ask you to consider is to leaving the this amendment, removing this amendment that's on page 211, starting at line 7292 and ending at line 7324, leaving that out, removing that, leaving the current law at 171223 as it is, and the defender community, the juvenile defender community, are a group of exceptional people. It's a calling, it's a service. Students, attorneys interested in public interest law are drawn to this, and we have always gone the extra mile and done those things that are necessary in order to adequately represent children in the juvenile justice system. Since 1994, the penalties have gotten so much more severe than they were. We used to have, when I first began back in 1980, March of 1980, it was a very much more benevolent system, let me say. There were very few children were actually charged with criminal or type offenses, and there was a much more, the courts were smaller, everybody sort of worked together and came up with treatment plans, and it was just a very different thing. Now, these detention centers, which I visit on a regular basis, are extremely similar to jails. I have to be searched every time I go in there. They look like jails, they sound like jails, they smell like jails, they are jails. And as has been stated by Giovanni, children don't have the same sense of time. Oh, no, I think this is Judge Key. Children do not have the same sense of time. A day or two for them in a place like that, which I actually call gang recruitment centers, because that's where most gang members get their new recruits, because you're cutting the child off from their family. Juvenile detention should be extremely carefully used, and the child should have someone who can adequately convey to the court what is going on in that particular child's life. I've had many clients who say nothing in their own behalf, and very often it's because they suffer from some intellectual deficit that makes it impossible for them to speak. So there is no question but what this is essential to due process, to have attorneys. Now, again, I don't know, and I'm perfectly willing, as I have in the past, to sit down and try to hash out a very good way of dealing with the situation, and there may be another situation. But taking away what uniformity and what progress we've made, I just can't see as a good solution or as an improvement in the life of children in this state. And that's basically what I have to say.
Any questions for Ms. Pace? Representative Bruce, hit your light. There you go. And pull your microphone to you.
Repeat the section that you were concerned about.
Yes, it's an amendment,
Oh, okay.
and it's titled Section 3.2.
You got it.
AM 29 1080.
I'm sorry. Do you find it now? This is what I was given as a number.
I don't have it.
Okay.
We're told by our expert legislative counsel that we have an amendment that touches the subject
Okay,
you
which one
were
is it?
concerned about. 1080. 29 1080.
All right.
Further questions for Ms. Pace? Seeing none, thank you for joining us today. Sandy Michaels, Georgia Association of Criminal Defense Lawyers.
Thank you, Chairman Jacobs. I'm going to be very brief because, of course, Linda Pace is one of our members, but I'd like to add two things. Again, I'm Sandra Michaels, the Criminal Defense Lawyers, and we've been working on this legislation for as long as we've been thinking about it, which has been a very long time. One, I'm going to echo Ms. Pace's request, and I believe it is to the amendment that's already in your file about removing the section that was added on in the Senate. I'd only like to add that I've had emails and phone calls all day long from public defenders and CPDs that want that removed from the bill that was put in the Senate and request that the bill remain without that section. And we represent public defenders and CPD people all over the state of Georgia, and I've been receiving information from them all day. The second thing is, I believe, is also addressed in an amendment in your file folder. I've not seen it, obviously. It's regarding a child making admissions at arraignment as to the crime they're accused of without being able to talk to an attorney first. For those of you that have heard from the judges and from Ms. Pace and others, children will admit to things they have not done, especially if their parents tell them to step up and do what they're supposed to do before a judge. There's there is a respect of authority, and they will say things without actually talking to an attorney. They could be admitting to things that could cause them a lot of trouble that they actually did not do. All of us know through criminal defense and through the indigent defense years that a case that is not being properly investigated before you resolve it leads to a lot of mistakes. So I believe there's some language from in the file folder, and if that's correcting that part, I would thank you so much.
I'm told that that amendment is AM 291090.
Yes. If I could just read it, sorry. Yes, great, thank you. That's all I have to say. We are in huge support of this bill. It has been a tremendous amount of time and cooperation, and quite frankly, a lot of folks have compromised on certain issues. We would really ask for your support of this bill. Thank you.
All right, any questions for Ms. Michaels?
Yes, sir.
Representative Welch, pull your microphone.
That's with the amendment that we're looking at as AM 291090. Is that correct?
Yes.
So support of the bill with the amendment.
Yes, that would be great, and with I believe
striking the amendment.
The section 3.2. Yes. Thank you very much.
Further questions? Seeing none, thank you for your testimony, Ms. Michaels. Sarah Tatanchi from the Southern Center for Human Rights.
Thank you, Mr. Chairman, members of the committee, and I will follow the chairman's request to not duplicate what people have said. I just want to represent that the Southern Center, as well as the Public Policy Advocacy Partnership of the Presbytery of Greater Atlanta, represented by Wendell Phillips here, and the Asian American Legal Advocacy Center stand in strong support of this legislation with the amendment AM 291080. We really believe strongly that that's a matter that should be handled outside of this bill, and we appreciate your support in cutting that section. Thank you.
Any questions for Ms. Tatanchi? Seeing none, thank you for joining us today. Deborah Nesbitt from ACCG.
Good afternoon, Mr. Chairman and members of the committee. First off, I want to commend the stakeholders of this group. We participated in that group. There's been a lot of work, a lot of years, a lot of compromise, and a lot of negotiation on getting to this final bill. And we don't in any way want to represent that we don't support doing what's best for children. We do, however, have a concern about the funding. And the chairman did address that at the beginning of the meeting. I think the DAs will speak to what it takes for them to handle their prosecutorial duties. But we really would like to see, there have been several financial studies that have been done that have been floated around. There was a fiscal note that was done on the CHIN services on last year's version. We still do not have a good, valid physical note for what resources it's going to take to implement this legislation. So we have respectfully requested from Chairman Willard that we do a physical note that would include both the local and the state costs so that we can adequately plan for implementation and know what the cost is going to be, both for the state and for the locals.
All right, questions for Ms. Nesbitt, Representative Bruce.
Yeah, just a quick question. And I've asked this of several people because I understand the concern around funding too. Has your organization or you or your organization thought about any possible ways to fund this that would not be devastating or harmful, or have y'all thought about that?
Chairman Willard said in his opening remarks that the prosecutors are state funded and state paid, and I did want to clarify that while that's true, their salaries, the counties fund a lot of their operations, and they also fund a lot of the additional ADAs that are in those offices. On the public defender side, in the juvenile divisions, while the Georgia Public Defender Standards Council requires the circuit public defenders to have a juvenile division, the counties are paying for 100% of that right now. And so any additional duties would then again be cost that would go to the counties. And as to your question, I don't really know where additional funding would come from to provide those services. There are no add-on fees or anything like that in juvenile court. So as far as looking for an additional funding stream, I really don't have any ideas as to where that money would come from. And I guess that gets back to what our issue is that we want, there's been a lot of work and a lot of negotiation, a lot of thought, and a lot of experts have given best practices in this legislation, and we want to see it succeed. We don't want to see it struggle along like indigent defense did for several years because they didn't have adequate funding. So we would just, if for nothing else, the counties need to be able to plan for what costs there are going to be to the county.
Yeah, the only reason I'm asking, because it seems like everybody is in favor of the bill. The difficulty, obviously, is around funding. But everybody's focused on the bill, and I think that if we all kind of shift for a minute and start focusing on how we're going to fund it, that might help.
I've kind of been the bad guy because I have been focused on the funding. So, I agree with everything in this bill, but again, I continue to say we need to identify, because it's not that far to July of 2013.
Right, but I'm saying if we all agree that this bill needs to come into fruition, we got to focus on the funding and focus on how we're going to pay for it. And I'm just hoping that all of us put our heads together to do that, so that we can get this done.
Well, we're already funding the largest part of it, so we would hope that the state would step up to the plate and provide the funding.
Thank you.
Further questions for Ms. Nesbitt? Seeing none, thank you for your testimony. All right, now I've got 6 district attorneys bracketed, so why don't we begin with Mr. McDade, and I'll let you tell me how we're going to structure this so it's not duplicative.
Mr. Chairman, what I would request is that we simply come up as a group rather than have 6 different speakers. And
that sounds like a great approach. Unfortunately, however, we have only 2 microphones, so maybe just have some stand behind and have whomever will be doing most, if Mr. McDade will be doing most of the presenting, why don't you introduce the DAs we have with us today?
Thank you, Mr. Chairman. Mr. Chairman, my name is David McDade. I'm the District Attorney for Douglas County. I'm also the President of the Georgia District Attorneys Association. Seated at the table with me are Kermit McManus, former District Attorney from the Conasauga Circuit, but also he's been probably the liaison between our group and the legislature on the drafting of this legislation, along with Mr. Tom Williams, an Assistant DA that is in the back. Seated next to me is Ms. Denise Faccini. Ms. Faccini is the District Attorney from Cordele, Georgia, and is here to speak briefly to some of the funding issues that rural Georgians face. Standing behind me is Mr. Pat Head. As he's moved, the studious-looking gentleman, Pat Head, the DA from Cobb County. And to my left is Mr. Ken Malden, the District Attorney from Athens, who is the chairman of the District Attorney Association Legislative Committee. Very briefly, obviously, we echo Ms. Nesbitt's sentiments in that everyone at this table supports what the goal of this bill is and the legislature's efforts to make certain that we have a juvenile system that works and that takes care of children. No one in this process disagrees with the merit of the bill that's before the committee for consideration.
We, unfortunately, are where the rubber meets the road. We are the prosecutors upon which tremendous obligations are going to be placed to carry out the will of the legislature in this bill. And we would be remiss in our duty to this body if we did not make it clear at every step of the process that while we embrace the concept of this bill, we support the concept of this bill, we very much are concerned that if it is mandated that we take on these responsibilities without sufficient funding, the good work of a lot of good people in this room and at this table will fail. And I will simply reach back about 5 or 6 years and offer this committee some guidance on what I'm talking about. It's been alluded to earlier. The public defender system in the state of Georgia for many years depended upon the vagaries of local funding. That was a process that developed over the years through the court system and through the judiciary, but there was no organized statewide system of funding indigent defense throughout the state. And ultimately what happened, as you saw and as you experienced, was that system failed. It depended upon the local jurisdictions to provide the funding that was necessary to provide adequate criminal defense. And I'm sure there are some in this room that are back there shocked that I'm advocating for a statewide public defender system. You've implemented one, but you implemented one because the system that depended upon local funding did not work. Both the state and federal courts ultimately concluded that Georgia's system that depended upon localized funding for such an important component of the justice system simply wasn't meeting constitutional standards. We all heard Chairman Willard. We understand his position that he's asking us to step out on faith and rely on this body to provide funding. We certainly recognize that Chairman Willard is a man of his word, but we have obligations too, and those obligations are that we must make certain that you understand that although we completely support the methodology and the thrust of this bill, it will not work if it is not adequately funded from the prosecution standpoint. We were asked by the chairman to come up with our best estimate of what we thought the fiscal impact would be on the prosecution community. We came up with a figure that the prosecution component would be somewhere north of $15 million to adequately fund the component that we're being asked to fund. That was our best effort in dealing with an analysis of what we were being expected to take on. We presented that to the chairman. And we are aware that there's another study out there by the Vera Institute that apparently somewhat unilaterally conducted their own assessment and came up with a different figure, something about half of that spread the funding between counties and the state. We are simply here to give you examples and hopefully a little bit better understanding of why we think it's so important that this bill must be funded if it's to go forward. That's our general view.
Ms. Fachin?
Good afternoon. I appreciate the opportunity to speak with you, and I'd like to start with identifying my particular circuit. It's a rural four-county circuit. We have categorized it as a low population area, and I'll just start straight out by telling you that this bill simply would not work in my circuit. While substantively I agree that the concern we show to courts that involve juveniles should be as much, if not more, than the concern we show to adults, the problem that we have is that I get absolutely no county funding for positions. I don't have a state county-funded attorney. I don't have a county-funded secretary. Everything in our office, but for I think approximately about $31,000 a year to fund copy machines and supplies and phones, comes from the state. My positions are all state pay. To implement a plan where we would have the counties paying any significant portion towards a prosecutor's salary or for the support staff is not workable. It's not going to happen. My largest county right now contributes $12,000 a year to my budget. My smallest county contributes $900 a year towards my budget. There's the Vera Institute that Mr. McDade alluded to, suggests that this be funded by prosecutors being provided at 60% county and 40% state, which would, if we took the average salary that they suggest, it would have my counties giving me $35,000 a year towards the salary of an assistant district attorney at I think a salary rate of what they found to be about $60,000, sort of a mid-range. $35,000 would be about 110% more than I get right now from my 4 counties combined. And so realistically, we can implement a program, but unless it's funded and specifically funded, and that those funds are identified and that they're provided by the state, it's going to be a house of cards. It's going to be just as irresponsible to put in place something that simply isn't funded and isn't actually going to be able to work than it would be simply not to address it at all. I ask that before anything is done in terms of this legislation moving any further, that the funding be addressed realistically and responsibly. Otherwise, you're setting up failure, and the victims of crimes of juveniles are just as much victimized by the juveniles who break into their homes, assault, commit robberies, than the victims of adult crime. We can't ignore that either. And neither do we ignore that juveniles need stronger, more identified services than most adults do in the courts. So the courts are important to juveniles, critically important, and we want to address those issues responsibly, but we have to have identified, dedicated funding for that, and we're not going to get it in rural Georgia from our counties. It's not there.
Anyone else want to speak to the bill? Mr. Malden.
Mr. Chairman, members of the committee, I'm Ken Malden. As Mr. McDade introduced me a minute ago, I'm certainly privileged to be here, and I just wanted to address one quick matter just to give you a sample there, just to concur with what Ms. Ficini said. Of the 49 judicial circuits, it really is handled, the funding mechanisms handled it differently. It's very much like the chairman indicated earlier. In some circuits, particularly in rural Georgia, it really is all the state. They get really no funding at all from the county, and there really isn't an opportunity to get funding further at all from those counties. There isn't money available really to for them fund their own budgets, much less to the DA's offices. In some circuits like ours, we do get some county funding, but it is few and far between. We basically had to be very creative to try to get the job done in Superior Court. I have 29 employees. 8 of those are state funded out of that. 8 of those are soft money through VAWA grants and VOCA grants and some little 5% money that we have. The rest of those are county funded, most all of that Athens, Clarke County, and a couple positions through Oconee. And really from 1995, 6 years before I even took office, was the last time either county had funded through the general fund any personnel. And it wasn't until FY10, the beginning of FY10, that I got any extra money when I got 1 ADA and 1 investigator for a total of about $110,000, try to make that work. That we were able to get anything from 95 until 2010. So if in fact it falls back of really any amount falling back on the counties, it's really probably just not going to happen. We've struggled to get it done just on the cases that we handle that we're responsible for right now. So just to concur with everyone else, if it's not funded, it's really not going to be what this good group and everybody else has been working on to try to accomplish. So.
If I may, Mr. Chairman, my name is Kermit McManus. I'm the recently retired district attorney for the Conasauga Judicial Circuit, and I'm currently lobbying for the District Attorneys Association. And this bill is one that I've been involved in for the past 4 years. I've been to all the stakeholder meetings, myself and Tom Williams, Assistant DA. And the bill has gone through many transformations and is a good bill. It is a good piece of legislation. It is very good for the state of Georgia. It is in a position that is going to revolutionize the juvenile court system in the state of Georgia. That is needed to be done for some period of time, and this bill will do it. But it can only be done with the funding in place. if funding is not in place by the state, and we believe it has to be coming from the state, because the counties, I know my county, when we get into this issue where the state's saying spend money that we are telling you to spend, my county commissioners just go to see red. I think that's kind of common. The problem is it just comes down to very simple. If there's a juvenile court judge sitting on the bench, there's got to be a prosecutor in the courtroom with him and a defense lawyer in that courtroom with him. We don't have that. We could not do that right now in about 2/3 of the state of Georgia. It's all about funding. We trust you to bring it to us. And with that, we can support the bill with the funding.
We hear Mr. Head yet?
Sometimes, Mr. Chairman, it's better to remain silent and call a fool than speak and remove the doubt.
Well stated. Well, I want to just emphasize again. I know there's a questions, and I'm calling on blind trust in some respects, but I plan to, upon the pass this bill, be sure that thank you. Be sure that the fiscal office, the budget office for the legislature is going to do a full study, because I know I've seen documents come in from various organizations, and it's all over the board as far as what's being suggested as the amount to fund these various parts and programs. So we're going to have to get some what I call better data. I think the legislators will be comfortable with what we pull in from our own budget office when they have the time, which they should have during the summer, to take some people and put onto that project. And as I said before, we know that the governor's office is supportive, and will listen to reason about getting funding done. Now, how it's divided up, I can't tell you that it's going to all fall on the state. Sorry, Ms. Nesbitt. But there is a responsibility, and has been a responsibility since the beginning of the juvenile courts with the local governments, and that's going to have to be recognized in the means of what we have from both ends. We've raised fees for the local governments and courts, and that's the way we try to help with that assistance too. Thank you. We are down to Travis Sarkison with the, is he in here? I thought Travis outside earlier. He may not be wanting to speak.
Travis had to step out.
He did? I'm not sure if he was going to speak anyway or not. He indicated he might or might not. That is all the individuals who signed up. I know we're also being given on the upstairs. If there's anyone who has not signed up but would like to address the committee, I'm going to leave it open for that opportunity at this time. If you will, just please stand up. We'll recognize you to come forward. Is there anyone else? I see no one else. I think we had a question. Mr. Welsh, did I forget to get you?
Wait.
You wave? Okay, sorry. If there's no one else, we will cut off further public comments at this time. And House Bill 641 is in the breast of the committee. We're working off the document in your file, which is LC 295170 ERS, and the chair will now open it up for discussion among members of the committee and Representative Lindsay.
Just at the appropriate time, Mr. Chairman, I'd like to make a motion.
All right. Do we have any comments or discussion by committee members before we proceed to motions? If there are no further comments, the chair will entertain a motion.
Move to pass, Mr. Chairman, all 243 pages.
Second.
It's been moved and seconded to pass. We have discussion on the motion.
I do have an amendment to offer.
Yes, sir. If we have no discussion as to the motion, the chair will now entertain amendments to the motion. And I'm going to, if you will stop and let me get your files organized with me. We have a number of documents, and I think they're numbered at the top, and I'm going to suggest we try to put them in order. Get my chair back up here. If you allow me to go through the numbers with you, We have one that is numbered AM 291092. That will be the first proposed amendment. Next we have is AM 291080. That would be amendment number 2. Amendment number 3 will be AM 291083. The next amendment will be AM 291085. The next amendment will be AM 291088. The next amendment will be AM, that's the one out, excuse me, AM 291090. Then we have the last one, I believe, is AM 291091. Does everyone have copies of those amendments in your files? Yes, sir.
We have in our folder, we also had an amendment AM 2989.
That's the one being replaced. Thank you for bringing it up. That is being replaced by what is AM 291092. Now, with that all in order, the chair will recognize, first of all, Representative Lindsay for an amendment.
Yes, sir. I have before you a proposed amendment 291092. The committee may recall that I believe it was last summer that we first discussed setting up a commission that would periodically look at the Juvenile Justice Code and make recommendations for changes. We found this to be very helpful with Child Support Commission that has come. Remember when we passed the massive overhaul we did in 2005 and 2006. It has helped keep child support issues up to date rather than allowing it to fall behind. I believe the last time we had an update of the Juvenile Code was sometime in the 1960s, and I want to see if we can avoid needing allowing things to lapse like we did over the Juvenile Code. And so that is my proposal. The 1092 basically sets up a commission very close to what we have when it comes to the Child Support Commission in terms of its membership and its duties to review how the proposed juvenile code is working and periodically make recommendations for changes. I do have a sunset provision in there to sunset the commission on June 30th, 2024. It may very well be come that time. It's working so well and doing such a good job, it should be extended beyond that date. But I think every commission in this state at some point should be reviewed again by the Georgia General Assembly to see whether or not it's doing what it should be doing, rather than simply perpetuating it into infinity. So that's my recommendation in my proposal, Mr. Chairman.
Thank you. Do we have a second? Do we have that already? I think that's your proposal. Is there a second to the amendment?
I'll second.
We have a second to the amendment. Discussion on amendment number 1, Lindsay amendment number 1. Any discussion? I'll just add to what Representative Lindsay has said. That you have 13 members, and what we've tried to look at in putting together those membership in the committee is various groups that have interest with the juvenile law. From the governors, you have appointments of Superior Court, juvenile court judges. We also have an appellate court judge, and those certainly have interest. And then we have the lieutenant governor making an appointment, the Speaker of the House making an appointment of a member of each body. Then we have the Commissioner of Juvenile Justice and the Commissioner of Human Services, the Commissioner of Behavioral Health and Developmental Disabilities, Director of Family and Children's Services. These are all parties who have direct interest and needs to keep us informed. Then we also have the Georgia Public Defender Standards Council appointment and the Prosecuting Attorneys Council appointment. So we hope we've pulled in everyone that we think is relevant to direct questions of how the legislation is working and where there may be needs to change or improve it. Any further discussion by the committee on Lindsay Amendment number 1? Yes, sir. Mr. Welch.
Thank you, Mr. Chairman. The amendment here, I just want to make sure we're clear that in lines 70 through 74, that that the expenses associated with the commission will be based upon what's available and when they become available.
Right. There would be a need, just as we do with the child support. The legislature does appropriate some funding through the executive branch on that.
Thank you.
Any further questions? If not, the chair will call for a vote on the Lindsay Amendment number 1. It does not change anything in the current bill. It adds to it. All those in favor signify by saying aye.
Aye.
Opposed, like sign. Next will be a second amendment, and this is going to be a Willard amendment. The chair will speak to this amendment. If you look at the amendment and read the fact that what we're deleting, go over to page the main part is on pages, line number 7274, 210. Thank you, sir. I want to call your attention to this because this goes back to what I was mentioning in the beginning of my comments. This was a section under Part 3, Injured Defense, Section 3.1, that as well as Section 3.2. The amendment seeks to remove those sections, and these are sections placed back in the what we'll call the Hambrick Senate bill dealing with injured defense. As I expressed earlier in my comments, rather than having anything within the bill dealing with the issue of the defense and how it's to be provided or not provided, we're leaving it current-wise, provision-wise, up to the court for that direction. That doesn't mean it's going to stay that way. It means that between now and the time next session in January, we'll have our studies done. We'll have better information about the financial costs. We'll have opportunity to talk to the various interest groups and look at how the funding is to be handled. As I mentioned, the governor, from information provided to me, is supportive of being sure there are funds provided, and this will be a way to not try to address under the legislation we're passing today what will be the obligations of the state or local governments with that issue. I propose the Willard Amendment number 1. AM 291080.
Move.
Second.
Is it moved and seconded? Do we have discussion on the amendment? There be no further discussion. The chair will call for a vote on the amendment. Willard Amendment number 1, which is amendment number 2. Signify your support by saying aye.
Aye.
Opposed, like sign. The amendment carries. Next is Willard Amendment number 2, which is amendment number 3, just to keep the continuity going on the numbers. This is changing a term. Again, I called your attention going to line 4750. Thank you. I got the wrong number. Excuse me. 4750, not 46. Yep. And what you're having here is a section dealing with we change a requirement of commitment, and what we're doing here is recognizing there again, as Judge Walker very eloquently stated, there be the right ultimately of the discretion of the court to make the decisions and not a direction under law. And this is really a change of language. It should have been changed. I think earlier I was mistaken on it. But if during the comprehensive service plan hearing or any subsequent review hearing, the court determines that the child meets criteria for civil commitment, it says the child shall be committed, and we're changing that to the child may be committed to a secure treatment facility. So the change is in line 4750, changing shall to may. I would propose that as Willard Amendment number 2.
Move.
Been moved and seconded. Any discussion on the amendment? There being no further discussion, we'll call for the question. All those in favor of support of Willard Amendment number 2 signify by saying aye.
Aye.
Opposed, like sign. That is Amendment number 3. It passes. Next we have is the Lindsay Amendment number 2, which is the AM 291085. Mr. Lindsay, I'll recognize you.
Basically, Mr. Chairman, we are seeking here to define best interest of the child, so that the issue of best interest of the child, rather the term best interest of the child, has a consistent meaning throughout the code. So we have basically adopted in large part the definition that already exists when it comes to child custody cases, and attempted to mold it into the juvenile justice proposal.
Thank you. And is there you propose the amendment? Is there a second to it? We have a second. Do we have a discussion on the Lindsay Amendment number 2, which is Amendment number 4? There being no discussion, further requirement of discussion, the chair will call for the question. All those in support of Lindsay Amendment number 2, which is Amendment number 4, signify by saying aye.
Aye.
Opposed, like sign. Amendment 4 carries. Next we'll have is the Willard Amendment number. Lost my track. 3, yes. Willard Amendment number 3, which is AM 291088. If I keep my numbering right and have any memory at all left, we are now dealing with amendment number, I think I said 4, this would be amendment 5. Amendment 5, ladies and gentlemen, is dealing with the what I feel to be a very essential part of what needs to be done before there is the commitment by a juvenile court judge of a child to state detention, and having that child removed from its community and home under any circumstances, and that is to be sure that we have what is known as the behavioral analysis made, which I refer to as a risk assessment behavioral health evaluation, and this will be, I suggest, not only a necessary tool, but one that will give guidance to the court to determine is it in the best interest to have the child removed. I think the present practice in Georgia is to try to do this in most cases, but it is not done in all cases. And I know in speaking to the officials with the Department of Juvenile Justice, our state does not have an option when a juvenile court judge subjects a child to detention by the state. The state is required to accept the child. Many times a child comes into state's custody and we realize that child probably is not best served by being in a long-term detention, but the state does not have an option about what is done or not done with that child. I think that's a terrible manner in which we're putting the cart before the horse, you might say, by placing that child in detention, and there's really nothing the state can do as far as even reducing the time. I believe that I'm correct in that assessment. So we need to be sure that we are at least using all the tools available. And as Judge Key pointed out, the great benefit of this is hopefully it will reduce the cost not only to the community, but certainly the cost to the state in realizing that we're paying out over $200 a day for maintaining a child in state detention, whereas you can have that child probably better served in its own community in most cases, many cases, at a cost of a fraction of that amount. So I have proposed the Willard Amendment 3, which is your amendment number 5. It's been moved. Is there a second? Second. There's a second. Any discussion on the amendment? There being no discussion, the chair will call for the question. The question is approval of Willard Amendment number 3, which is the Fifth Amendment. All those in favor signify by saying aye.
Aye.
Opposed, like sign. The amendment carries. Next we have is the amendment AM 291090. This has not been assigned to anyone. I'd be glad to take it if there's someone else wants to present it. We're happy to do so. This is dealing with the issue that was raised earlier about, I think, a change, part of a change that came out of the Senate bill that we want to go back and readdress, and that is a child being brought in and is before the court in an arraignment situation, unrepresented at that point in time, and there may be statements or utterances by the child that deal with the questions of admission or denial of responsibility of what they're charged with. Just as we have recognized with adults, those charges are, those statements can be set aside. We feel there's also the same duty recognizing a child who is unrepresented and not knowledgeable of the or unknowledgeable of the circumstances of what may be his statements, needs to have the opportunity to address this with an attorney and then be advised what should or should not be said. Even though some statement may already have been made, it cannot be used against that child because of those circumstances. And do we have a motion on the amendment? This is the Willard Amendment number 4, and it is amendment number 6. Do we have a second? You know, a second by Ms. Oliver. Discussion on the amendment. We have Mr. Dixon. Was that you, Mr.? I'm sorry, not Ms. Dixon.
No,
Ms.
I
Welch.
just wanted to clarify that this also pertains to any statements made by a child who is represented by counsel. So it's whether you're represented or unrepresented.
Correct. If made without counsel's permission, might say, but that's part of correct. Any further discussion on the amendment? If not, the chair will call for the question. The question is amendment number 6, which is the Willard Amendment number 4, AM 291090. All those in favor of Amendment 6 signify by saying aye.
Aye.
Opposed, like sign. We have approval. The next amendment is also, I think, a request that came from the Prosecuting Attorney's Council. If you will bear with me for a second, I will also take this as a Willard Amendment number 5 and Amendment number 7 on the listing of amendments. This amendment addresses a change where we had the term original by changing that to exclusive. Bear with me and go to lines 56, 66, if you would. Thank you. 164? Yes, sir. Thank you. Okay. And I'm going to ask Ms. Travis to bring us some information about the purpose behind the amendment and what it does.
The language also in the bill talks about when cases are in the exclusive original jurisdiction of Superior Court, and this change adds the word exclusive on line 5666 to make it consistent with the remainder of the bill, so that if the Superior Court has exclusive jurisdiction, then certain circumstances dictate how transfers occur.
All right. So we're changing on line 5666, the word original, to exclusive by the amendment. Do we have a motion?
So moved.
It's been moved and seconded. Any discussion on the Willard Amendment number 5, which is amendment number 7? If not, Chair will call for the question. That is for approval of the amendment. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. And I believe that concludes all the chair's known amendments. Does anyone else have other amendments they wish to offer at this time? There are no further amendments. Any further discussion or question regarding House Bill 641 under LC 295170 ERS as amended as a committee substitute? Did I get it right? It's a committee. Amend it and be a committee? No, it'll be a committee substitute. Sorry, Mr. Welch.
Thank you, Mr. Chairman. This is an amazing piece of legislation to have tried to read through over the last 2 weeks. But I think that what obviously this is needed. My concern, and I just wanted to vocalize it, was that we do everything we can to ensure that we have the funding for this. Otherwise, it's really just words on paper, and that would concern me greatly if we don't work next session to find that funding mechanism. Otherwise, I will lend my support to it.
Thank you. And that's another valid point. As I mentioned, that we've got our vice chair in appropriations, public safety, in with us, and as I have said earlier,
Somebody move the box.
Representative Powell, we are going to ask our budget office to do a very detailed analysis for costs that may be associated with some of the policies that we're addressing here, and come back maybe after the summer if they can do that, and come back to us with some information reports of where we're looking at costs and how that funding can occur. So that is a pledge of the chair, and I believe of all members of the committee. I don't think anybody wants to disagree with that, is there? And with that, the chair, any other comments before we call the question? The question is for a due pass of HB 641 as amended as a committee substitute. All in favor signify by saying aye.
Aye.
Opposed? No opposition. Ladies and gentlemen, I am grateful to all of you. I think you've recognized a great step of what we're seeking to do in improving our juvenile system in Georgia, and this is a major part of it. Thank you, Mr. Jacobs.
I just wanted to be recognized for an announcement, Mr. Chairman. I had scheduled a subcommittee meeting for tomorrow instead of holding that meeting tomorrow because the next Judiciary Committee meeting is not until Tuesday. We're going to hold that meeting on Monday at 1 p.m. So no meeting of my subcommittee tomorrow.
If there's nothing further, we will stand adjourned. Thank all of you.